Welcome everyone to the Federal Bar Association Key Tam Sections, the Rounds FCA News with Tejinder Singh, our 2022 version. The Rounds is Tejinder's regular analysis of noteworthy FCA decisions. I'm Scott Oswald. I am chair of the Key Tam section with Tejinder Singh, partner at Goldstein and Russell. Happy New Year, Tejinder.
Happy New Year to you. We've got some good stuff today.
Boy, we really do. And a few topics that we have covered in previous versions of the rounds. The first is Sheldon versus Allergan sales, a Fourth Circuit case, Tejinder, which deals with Safeco rationale in FCA cases. How does the Fourth Circuit come out on this issue?
Yeah, so Scott, we've talked about this issue before in the connection with the Seventh Circuit's Schutte versus SuperValue case. There's this roiling debate about whether the Safeco Sienter standard, which says that if a defendant has an objectively reasonable interpretation of a legal requirement, and there's no authoritative guidance warning the defendant away, can it be found to have knowingly violated that requirement? The Seventh Circuit said no in a pretty controversial decision, and now the Fourth Circuit has agreed largely with the Seventh Circuit, a 2-to-1 decision holding that if the defendant's interpretation of a relevant legal requirement is reasonable, they can't be held to have knowingly violated that requirement.
So there seems to be this dichotomy between what the defendant knew and when they knew it and when they're kind of putting forward their rationale to gender. How does this all work?
Yeah, this is a tricky one. So in the Fourth Circuit's decision, what isn't clear is when the defendant had to have believed what it believed about the law. So in the decision, there are parts where the Fourth Circuit says, oh, the defendant has based its actions on a reasonable interpretation of the law. And there are other places where the Fourth Circuit comments on the history of the particular law at issue, which is the best price rules for rebates to Medicaid on drugs, and says, well, at the time there was this conversation, there was a lot of uncertainty about it. That's a potential contrast with the Seventh Circuit's decision, which said that the defendant's subjective understanding and intent is irrelevant. In the Seventh Circuit's view, even if at the time it submitted the claims, the defendant thought it was submitting false claims, that's not a problem. It's kind of unclear whether the Fourth Circuit agrees with that view. It cites favorably to the Seventh Circuit's decision, but there are these other indicia that raise some ambiguity about it.
And the Schutte decision that we talked about before, what's the procedural posture there?
So that case, there was a petition for rehearing that was denied by the Seventh Circuit. The relators, who I represent, by the way, are going to be filing a petition for writ of certiorari. The current due date for that petition is in March, but we expect there to be an extension of at least a month.
So let's turn to C2A dismissals. It's been a common theme through a number of our programs, and we've got 2 decisions. First by the 11th Circuit in the Farmer versus Honduras case, and then the second is the first in US XRL Borzilleri via Bayer Healthcare. And they get to the same point, but maybe a little bit differently, Tejinder. Tell us about these 2 cases.
Yep, so these are 2 more cases saying that the government has pretty broad discretion to dismiss FCA cases. In the Borzilleri case, which is the one in the First Circuit, the court holds that they're entitled to dismissal unless the relator can show that the government's decision to seek dismissal violates the Constitution or constitutes a fraud on the court. The court says you got to have a hearing about this, but the relator bears the burden to make that demanding showing. The 11th Circuit decision maybe cuts the relators a little bit more slack, but not very much. Says, well, you know, the government has the right to dismiss. It doesn't have to first intervene to do so. But when they move to dismiss, they're constrained only by the Constitution, by the federal rules of civil procedure, and by any other applicable statute. And they say those constraints are pretty liberal and will seldom, if ever, be violated. There's a concurring opinion in that case that says maybe the government has to intervene first and that the 11th Circuit should think about that en banc. They may not get a chance to because there's a cert petition currently up from the Polanski case in the Third Circuit on this question, which recognizes that the circuits are all over the map on procedurally and substantively how dismissals work. The bottom line, though, is that both of these decisions are pretty permissive for government dismissals.
In some, government wins, relator loses.
Seems to be the trend in these cases.
Okay, let's move to US ex-rel Bryant versus Community Health Systems, a Sixth Circuit case. And this dealt with the award of attorney's fees after a more than 7-year battle. Tejinder, what happened here?
Yeah, so this is a crazy long fight over attorney's fees. You sort of think of attorney's fees as not the dog, but the tail. But this is a wag the dog situation in terms of the amount of litigation going into it. What happened here is that there were multiple relators who came together, forming like Voltron, to pursue this claim together with the government against the defendant. And it eventually resulted in settlements that had all of the relators getting paid pursuant to an agreement among themselves and the government. And the defendant said, hey, you can't all be prevailing parties entitled to your attorney's fees because you didn't get the money, directly from us or from the government. You got it through this other mechanism of the settlement agreement. And by the way, the first to file bar and the public disclosure bar will box some of you out from getting any money. And so those folks shouldn't get any money. And so they were trying to cut back the amount of attorney's fees that they would have to pay. And broadly speaking, the Sixth Circuit holds in favor of all the relators, saying when you come together in this manner, these last-ditch efforts, as the court describes them, to deprive you of your reasonable attorney's fees are unwarranted.
Voltron does, in fact, get his fees.
Voltron is on the path to getting fees. On remand, the relators will still have to substantiate the amount of the fees was reasonable, but the idea that they are all prevailing parties entitled to fees seems now settled.
So what's the implication of this case here? It seems to suggest that this group approach by relators could potentially be a model where all the relators, if they are providing information, they come together, they might also all get paid.
Yeah, it certainly does that. And I think it assuages one of the concerns that the lawyers might have had in broaching such deals, which is that, hey, am I going to be able to claim my own attorney's fees in that situation? I think it creates more incentives for cooperation among relators, which is only to the good. It will only result in more frauds being uncovered and redressed. And it also potentially increases the exposure for defendants, though, on attorney's fee liability. If defendants were counting on only paying one relator's attorney's fees, they need to understand that when many relators come together, they may be on the hook for more.
Let's turn to our last case, US ex-rel Yates versus Pinellas, Hematology and Oncology, again out of the 11th Circuit. And this case deals with the application of the Eighth Amendment's prohibition on excessive fines to gender and to clause 2 the penalties provisions of the False Claims Act. That's something we've addressed directly before. How does the 11th Circuit come out?
So this case is super duper interesting. Broadly speaking, the 11th Circuit comes out in the relator's favor, allowing a pretty substantial monetary penalty to be imposed. But the way that the court gets there is actually really quite interesting. So what happens in this case is that there's a medical practice that has its own clinical lab, and it buys another medical practice that has its own clinical lab. And under the Clinical Laboratory Improvement Amendments, each of those labs has to have its own certificate, its own CLIA certificate. And they both did, but when you buy a new lab, you have to get it a new certificate. The certificate doesn't transfer over. And in this case, the buyer didn't do that. And they kept submitting for reimbursement claims for lab tests from the lab they bought, but it didn't have a valid certificate. And so to get around that, they used the certificate from the original lab. And then when those claims were rejected, they altered the claims to say, oh, actually, the tests were performed at the other lab for which we have a valid certificate. And so this went all the way through a jury trial. And the jury found, yeah, you submitted thousands of false claims. They were materially false, submitted knowingly. It found the government suffered a total of about $775 in damages, which is not, that much, but it was trebled to $2,266. Probably still not worth a jury trial, but not nothing. And then the court found it applied civil monetary penalties of $5,500, which was the minimum penalty for conduct at the time, per violation. And that added up to $1,177,000 in civil monetary penalties. So the court goes through an analysis where first it talks about what the right measure of damages is. And it says the right measure of damages in affirming the $775 award was the difference between what the government paid and what it would have paid had the claims been truthful. The court said so interestingly, the defendant challenged that $775, said, nope, we want those couple bucks back, because they said the government didn't suffer any damages at all, because all the lab tests that we claimed were done were actually done. And the court says, nah, they suffered, a couple bucks of damages, why not? And so it says, even if the government doesn't suffer these direct monetary harm, the jury was entitled to find some damages here. And then it goes on to the penalties and asks under the excessive fines clause, was this excessive? And that's a pretty interesting inquiry too. So it starts by saying, okay, the excessive fines clause does apply to False Claims Act penalties, even when it's a private relator carrying the action forward. And there's some debate about that, but the 11th Circuit holds, look, these are effectively just civil penalties like any other fine. They're going mostly to the government. Their purpose is deterrence. And so they're going to fall within the scope of the excessive fines clause. Congress can't just pass a statute saying a private person can seek unlimited penalties on the government's behalf. There got to be some constitutional limitations on that. It's not a crazy result at all. It then applies the excessive fines clause to these penalties and finds that they are okay. It says the defendant is in the class of folks for whom these fines were designed. That is, people who are defrauding the government, especially its healthcare programs. It says these violations were done knowingly and they were material, as we found before. It doesn't matter that they didn't result in a lot of financial harm to the government, because part of the reason the fines exist is because the government has interests outside of only its narrow pecuniary interests that the fines are designed to protect. And then it says, and by the way, these were minimum fines. The fines were the $5,500 penalty, which is the low end of the penalty scale. They could have been twice as much per violation. And over time, the fines have increased, or the penalties have increased with inflation. And they were much lower than even the minimum amount of inflation adjusted available today. So the court says that the fines are reasonable and affirms the award of those penalties to the relator.
And this is important because in many instances, the harm to the government isn't just financial. Do you agree with that?
Oh, absolutely. I mean, if you think, for example, about the anti-kickback statute, which is probably one of the most fruitful places for False Claims Act enforcement these days, you can be a physician who gets kickbacks but still provide top-notch service. Nevertheless, these claims are false, and we don't want kickbacks tainting the provision of medical services. There's lots of reasons why that's true. It compromises medical judgment. Sometimes it can lead to medically unnecessary treatment, but not all the time. But still, the problems persist. It corrupts the practice of medicine in ways that are harmful to patients, harmful to payers. And I think it's entirely sensible that the government has policies in place that are designed to deter that, even in the absence of the ability to prove financial harm. Or you think about contracting preferences for the Small Business Administration or other government agencies. There's all kinds of programs where someone could obtain a contract by fraud, provide adequate services or goods under the contract, but nevertheless, the government is not really getting what it paid for. The government is getting deprived of the benefit of social programs that can be very valuable for propping up the economy as a whole. It's getting deprived of the benefit of a separate agenda to ensure fairness or equity in the contracting process. All those things matter, and there should be mechanisms to vindicate them with monetary awards.
And speaking of monetary awards and inflation, Tejinder, the monetary penalties under the Federal False Claims Act increased in January of 2022 from $11,803 to $12,537 at the low end $23,607 to $25,076 on the high end. What do you think about the government? Do you think they'll start to negotiate not just on damages, but on penalties as well in the wake of the Pinellas case?
I mean, they ought to, Pinellas is a good illustration of the type of case in which you can have a lot of liability flowing from the penalty provisions as opposed to damages provisions. And I'm thinking of cases that just involve a really large number of claims where the delta between what the government actually paid and what it would have paid had the claims been truthful is low. Let's say there's a prescription drug claim where what you do is you kind of effectively juke the price of a drug by a couple of dollars, but there are thousands and thousands and thousands of prescriptions. And that seems like a clear example of where the penalties are really going to swamp the damages. And so I do think that defendants, because they face that exposure, these penalties are mandatory per violation. They need to negotiate in light of those. And I think that parties on the other side of the V, relators and the government, need to recognize that penalty liability, especially as it grows with inflation, can become a very significant part of the overall picture.
Tejinder, thank you. And thank each of you for joining us for this edition of the Rounds FCA News with Tejinder Singh. We'll see you next time.